conduct yourself honorably and honestly. Number 4, you have a duty of courtesy towards judges, opponents, and witnesses. Awukwazi ukudelela inkantolo, awukwazi ukudelela i-witness, awukwazi ukudelela channel. I hope you guys are doing well and welcome to today's video. So let us speak about court decorum. Why do I think this is important? We saw not so long ago with the famous advocate of the 4 accused. I won't mention names. It sparked a conversation of how practitioners no longer care about decorum, no longer care about the nobility of the profession. We are part of a noble profession, and as candidate attorneys coming in, we must remember all of that. I think it's important, unless you don't just want it to be a noble one. But for people like me who think it matters, I think let us remind ourselves what decorum is all about. The way you dress, the way you speak, the way you address the court, how everything goes on in court. Let's start with, how do you dress to court? Pristine white shirt, a white shirt, a dark jacket, dark pants. I have my laptop here. Dark jacket, dark pants, and as attorneys, as people appearing in the High Court, all practitioners are required to robe. Magistrate courts, all attorneys, candidate attorneys are required to robe when they're in court. So the blouse must be pristine white. Can't get away with a very light blue, but the color is pristine white. All right, go pristine white if ngawas. Shoes must be closed, and if you are female, your shoes should not show the back of your heel. It's that simple. So it should be covered. Basically, you can't wear my sandals, my heel. You can't wear my sandals and say, no, this is a formal shoe, because a heel, no, it doesn't have to be a heel, but it has to be closed. Even my pumps, but vanilla valet can get move, and they should be with so shoes that are without a strap. If you decide to go as casual and as color, because they aren't tight on your feet, can get away with a shoe without a strap, but it's not gonna be annoying in court. In terms of robing, if you're going to be going in chambers, you don't have to robe. And if you're going to be doing a matter after hours, because there are certain urgent matters where you might be meeting a judge at a restaurant, meeting a judge at a garage or wherever, dealing with a very urgent matter, you don't need to robe there, but you have to look presentable, you have to look formal. That's what our profession requires. If you don't want that, why are you even part of the profession? That's what I just don't get. This profession is made up of seniority, it's made out of professionalism, and if you don't want that, I don't think you should be part of it. I honestly don't. I'm sorry. With that said, don't put on your robe in court. A robe, if court starts, the first thing you do is take your robe and go outside, robe, and come back in. You can't robe By pam I mean with the presiding officer in court, whether it's a judge, a judge, whoever. Don't robe inside. So it's always better to come in usugqokile. You don't robe when you are coming into court, maybe to observe, coming in to give evidence, coming in to just observe court, and you're just there for other reasons, maybe coming to give something to your colleague or whoever. You do not robe then. The purpose of robing, by robing I mean putting on your court gown. you only robe if you are there to represent somebody. A robe is there for that significance. Ukuthi I'm representing umuntu. That said, let's talk about introducing yourself. I did speak to you guys about my first time appearing in a civil court, and I didn't introduce myself, and it was hell. So the first thing that you need to do is introduce yourself to your colleague, your opponent, and then also go and introduce yourself to the presiding officer before court starts. And when you're going to introduce yourself, go with your opponent or somebody that can accompany you. You don't just go into court alone, into chambers alone. And nakhona, have manners. Don't, if Kuguti, you are on first name basis with the presiding officer and you are with your colleague, you don't do that. You don't come in and say yadi 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 sawubona bani. No, you don't do that unless all three of you are on first name basis. That's what you do. And what else do you do? If you happen to not have introduced yourself before court starts, you were late, before you do your matter, you introduce yourself and you apologize for not going into chambers. With COVID-19, I know we were not allowed to go into chambers, so say that, Guti, I was introducing because you're not allowed in chambers. But introductions are very important when you're coming into court. You match or I'm gonna keep on referring to magistrate because attorneys usually appear in magistrates and candidate attorneys appear only in magistrate courts, so that's why. Another important thing is when addressing in court. What do? You should know, how do you address a magistrate? How do you address a judge? How do you address a magistrate? It's your worship. How you address a judge, it's lord, lordship, whatever. And how do you address a judge of the Supreme Court and Constitutional Court? They are called justices. Addressing them outside of court, it's fine to refer to them as judge. You can refer to them as judge. And yeah, and then what else? I have a document here that says that when you're introducing yourself to a judge, by judge I mean in higher court, you can't just go directly start with the registrar or with the secretary in order to go and introduce yourself or whatever, because standards are different. You should understand that. And it's very unfortunate that people that had TV time were addressing courts in ways that were questionable. When you are writing to court or when you are hashing up matters in court, address them properly, have manners. Even there, like, our duty is to the court before our clients. Even if your client is so frustrated about a matter, when you're addressing the court, you have to have manners because you have a duty to the court. You are bound to be off duty to court. So entering and leaving court in matters. So first things first, you bow to the presiding judge if esekhona. Mengabe ungena noma uphuma. Mengabe ingena a judge, the court orderly will obviously say all rise if they're not there. Sometimes court could start and the court orderly is not there. You'll all stand, and apparently in high court you do not ask to be excused, but in magistrate court, before you leave, you ask to actually be excused. In high court, you just don't leave after you finished your matter. You leave when the next matter is called. So that's the difference in high court. This is a document about high court in Durban, by the way. And then, how do you bow when leaving? Do you bow before you open the door? You don't open the door and then bow. No, you bow and then you open the door. Leaving, again, konama courts that are positioned in bad ways. Guti mengabudlula fanele udlule ngaphambi kwe-practitioner that's currently addressing the court. Don't do that. Rather wait. And then again with leaving, You do not leave court when only your matter is the second to last matter, unless obviously it's arguments or it's a trial. But in a motion court, in a motion matter, you don't leave when there is but one practitioner left. You wait for the matters to be done and then inkantolo iphume, then iniphume kanye kanye. That's just manners. Ngeke ushiye inkantolo nomuntu yedwa. But if it's an opposed matter, obviously, if it's a trial matter, you are allowed to leave. You can't be expected to sit in for 2 hours of arguments or 30 minutes of arguments, if that be. And then when handing up things to court, I want to mention that when handing up things to court, you should ask for permission. May I approach the bench? May I do this and that? You don't just, $9. What if it's something that's not supposed to be given to court or whatever? So you ask to actually hand things over. You do not lecture the judge about law. Now this is what the law says. No, you don't raise points to the court. You don't do that. So yeah, don't do that. Could address it in chambers, in private, but in court you don't make them feel little, because they will make you. They could even charge you with contempt. So don't do that. And don't use words like thank you. In court, you don't say thank you to the court. You say, I'm indebted to the court, because you don't owe the court gratitude. You just don't. So, but if you want to express it, you say, I'm indebted to this court. Because they're doing what they're supposed to be doing. They're doing it not because we're also grateful, but because it's what they're supposed to do, ideally. So when you say, it's a different story. Then don't sit in front if you're a junior practitioner. Don't do that. In high court, as junior practitioners, as whatever. But even in normal court, as a junior practitioner, even in thingies, in normal courts, normal courts, it's usually just a bench for practitioners. But in a court that has motion courts, I'm a high court, where it's just for practitioners to sit, you don't take the first seat, you go and sit at the back. When dealing with issues where you feel that the judge wants clarity on or is somehow a bit confused about something, you don't say you appreciate the points. Judges don't make points. Magistrates don't make points. You appreciate the difficulty, the concern of whatever that they are raised, and so you're going to address them. You don't say, I take your worship's point. You don't do that. That's not good manners. You'll need to learn manners, guys. Like, one thing you'll need to learn is manners. Conducting yourself, the way you sit in court, the way that you, while waiting, is very important. So what you need to do is, you need to act with dignity. You need to, even when you are reading, you can't just read or take earphones or fagaz nglebeni. You don't do that. Ungalal. Rather go wait outside, of which you're not supposed to wait outside because the court is in session and you're still on the roll. You're supposed to be inside the court. When re-examining witnesses or when cross-examining, if need be, don't ask the same questions that were asked. Don't, unless you want to clarify, if you feel there's a need to clarify. But you just don't have to do that, because you're wasting the court's time and the court does not appreciate its time being wasted. You're wasting everyone's time. So the best thing to do is not redo, isn't. Especially if your re-examining or your cross-examining does not affect your case in any way. So why are you doing that? You're just wasting the court's time. There's this tendency of wanting to surprise colleagues or embarrass colleagues. We are called learned friends for a reason. So if you have something that you will be using for your own whatever, for your matter, and you want to do that, you don't do it by embarrassing a colleague yakho, by not making them aware of that. So if it's an authority, something that your opponent is not aware of, you have to make them aware of beforehand, so that if they are being misled by their client, say for example you're doing a bail application and usufikile enkantolo and you tell your the prosecutor that my client has no criminal record, and they check the docket and it says no, SAP, what's it called, SAP 69 says that they have a criminal record. As the prosecutor, have to make them aware, so that they do not become embarrassed in court if they are lied to. They do not become embarrassed in court if they were misled by their client. So yeah. And then when you are presenting cases you don't need to say the full citation. It could be S versus Makwanyane. You don't have to say the name and the year unless the court wants you to address them to that particular citation for their own reading. But if you can just refer to the name and the surname, the parties, and that's it. That's the only thing you need to do. 4 things that are important for practitioners. 1, the first and overriding duty is not to your client, but you have a duty to the court as an officer of court. You have a duty to the court. 2, you must act at all times with integrity, whether dealing with your client, dealing with the presiding officer, dealing with your colleague. You have a duty to act with integrity at all times. Number 3, you must advance the best interests of your client without fear or favor, to the best of your ability, but you must conduct yourself honorably and honestly. Number 4, you have a duty of courtesy towards judges, opponents, and witnesses. Awaz ukudelela inkantolo, awaz ukudelela witness, awaz ukudelela opponent. You have a duty to have courtesy, to be courteous. Yes, you have that duty. So all right, hope you guys enjoyed this video, and now don't forget to like, comment, and subscribe, and have a